it's absolutely wonderful to see such a full house. My name is Professor John Durans. I'm the director of the Whitlam Institute, and it's my honor to welcome you on behalf of the Whitlam Institute and our sponsor, William Roberts Lawyers, to this, the inaugural continuing professional development event in a series broadly entitled Whitlam's Legal Transformations. This inaugural seminar provides a spotlight on the contemporary challenges of the provision of legal aid services since the establishment of the Australian Legal Aid Office, the forerunner of the modern legal aid services, by the Whitlam government in July 1973. It's now my distinct pleasure and privilege to invite Uncle Michael West to the front from the Metropolitan Local Aboriginal Land Council to welcome us to country. Uncle Michael is a member of at least 7 boards. He's very busy and we're very thankful to have him here with us today. He's also, I think, I'd like to mention, the director of the New South Wales Indigenous Chamber of Commerce, as well as co-chair of the National Sorry Day Committee. We're very privileged to have Uncle Michael West with us to welcome us to country. Thank you, Michael.
There were a couple of previous roles that I've had, but over the years, and when you think about your time that you have, I resigned from a couple of them because I think there's a lot of other things to do. I had my time there setting them up, like the Chamber, National Sorry Day, also working on the curriculum, because that's important across the country. And we are going through very interesting times, aren't we, currently? The world is in very interesting times, one might say, the last few years. Not only pandemic, but we've also had and having the first war in Europe since about 77, 78 years, yes. And as humans, we can do better. I'd like to say, Bujadi Gamarua Gadigal Eora, g'day, and welcome to Gadigal and Eora land. And I think it's always an opportunity to get people to think with a welcome to country and to educate people. And it's so important. We need a lot of education and we can be better people than what we are now. Remember that we are not just Australians, but we are global citizens of part of this earth. As I said, look, I think it's important. You're probably told not to use your phones, but I'm going to get you to get your phones out. And we're going to have a look at a couple of things. And this will put some context into what I'm saying. So those on my right, I will get you to look at Brewarrina fish traps. Brewarrina fish traps. And on my left, I will get you to look at Huntingbird Manuscript Vatican. Huntingbird Manuscript Vatican. Now the point being that Aboriginal people didn't sit around here singing Kumbaya. Aboriginal people traded and amongst ourselves for more than 65,000 years. And we also traded up into Asia. And that was up the top end there. There was sea cucumber production plants for 400 to 500 years. And that was with the Macassans, the Indonesians, and up into China. And I made this point at the 50th anniversary of the diplomatic relations last year that Gough Whitlam started with China. And I know the ambassador appreciated that understanding that we have a history of trade and culture with China for many centuries. And that maybe looking at the past is a way for looking to the future, I think. And the Huntingbird manuscript in the Vatican, what did you find there? You'll see a very familiar face. Yes, they cause a bit of chaos. They like chewing things and destroying things, making a lot of noise. And you'll see a cockatoo in there. Correct, yes, I see everyone nodding. And that is almost 800 years old. It's 1241, almost 800 years old. You'll see that. And then Brewarrina fish traps, when you look at that, it's the oldest known human construction in the world today, more than 40,000 years old, and it's still working. I was talking to someone not long ago. They're still maintaining it. It's been a little flooded of late, of course, but it's still working. That's aquaculture and engineering. So we should be proud of that. And all Australians, as I said, has a responsibility to look after our culture and our sites, because they're your culture and sites to protect for humanity, and we need to do that. Now, it's important that we do take a moment's silence to pay respects to our ancestors, because obviously many cultures and all cultures do pay respects to ancestors. We will become ancestors one day. It's a natural scheme of things. And also we need to pay respects to all Aboriginal and Torres Strait Islander tradition owners, elders and custodians of the past, present and future for looking after the wonderful country that we now call Australia and the spirit of the country. And we need to remember those we have lost the last few years through this pandemic, which we are still currently going through. And we need to remember that, because we are on a current amber alert, heading towards winter. And we need to remember that they weren't just numbers, they were people with faces, they were people with names, they had their own families and their own communities they belonged to. And also it's important to reflect your own journey through life and where you are right here now in the continuum. And also pay respects to those, the last few weeks has been a very difficult time, hasn't it, for some people in Turkey and that in Syria with the earthquake. And we do live on a living planet. We need to remember that, and we need to all come together as good global citizens. So if we have a moment's silence to pay respects and to reflect. Thank you. Water falls from heaven, lands on Mother. It finds its ways to the rivers and to the ocean. We have 3 rivers, the Hawkesbury, Nepean and Georges. These are the aquatic boundaries of the Eora Nation. To my Aboriginal and Torres Strait Islander brothers and sisters, we warmly welcome you from country, from clan, from tribe, from nation. And to all our brothers and sisters, we all belong to ultimately one mob, one tribe humanity. We warmly welcome you from your family, your neighbourhood, your community, and ultimately the country you come from. We share little planet Earth here, floating through the ever-expanding cosmos. We need to look after Mother Earth, because everything we have, from our clothes to our buildings to our food, comes from Mother and is provided by her. We haven't been respecting her the last few years, for decades, and we need to look after her. And we've seen this through floods and through firestorms. And we need to, I think, get back to understanding the traditional knowledge that Aboriginal people have that we've gained over 65,000 years. But we've been here since time began, and we'll be here till time ends. And it always was and always will be Aboriginal land. It's never ceded. And we have some very important conversations to continue this year and moving forward. Not only about voice, but about treaty, about land rights and many things that need to be come to a proper outcome for all of us. And we need to be honest in our conversations. We need to be honest. And law sits behind everything, as we understand, and that for me, myself, the law impacted on me as a baby before I was born. I was born up here in Crown Street Women's Hospital. I was taken as a baby, a part of the stolen generations. So we need not to repeat these things, and we need to acknowledge them, and we need to get the right services for people and for families and communities. And there is a lot of trauma out there sitting underneath everything, but we can, as a society, do a far better job than what we are doing right now. And I think you all agree with that. And we can show the rest of the world when we appreciate diversity and inclusion, and no matter what postcode you were born in, no matter the colour of your skin, the shape of your eyes, and regardless of gender that you identify as, you should be able to fulfil your dreams and aspirations in a fair society. And hopefully that's what we're going to keep creating moving forward. And obviously it's World Pride starting this week. So we have many people from around the world coming here. So it's important that we set a great example to continue this journey of inclusion. Thank you.
Well, thank you very much, Uncle Michael, for that warm and very insightful welcome to country. And let me, on behalf of all us present, acknowledge the traditional owners of this land and pay our respects to elders past and present. Well, for those of you who don't know me, my name is John Faulkner and I chair the Whitlam Institute. And on behalf of the Institute, I welcome you all, very warmly welcome you to this afternoon's seminar. I do want to commence my remarks by placing on record our sincere appreciation to His Honour Chief Justice Alsop and all those from the Federal Court of Australia who've been so generous in hosting us today. The Whitlam Institute decided, as part of our Whitlam Government 50th anniversary celebrations, to organise a series of legal seminars commemorating aspects of the law reform achievements of the Whitlam governments from 1972 to 1975. Over the course of the next 3 years, we hope to hold seminars to examine the history of the introduction of the Racial Discrimination Act, the Trade Practices Act, the Family Law Act, as well as considering the contemporary significance of those reforms. Seminars have also been proposed to explore the significant legislative changes brought about by the 1974 joint sitting of the Parliament and legal issues relating to the 1975 constitutional crisis. Colleagues, we took the view that there could be no better place for us to start this considerable program than with an inaugural seminar addressing the issues of legal aid and equality before the law. The establishment of the Australian Legal Aid Office in 1973 was a milestone in the creation of modern legal aid services and funding in Australia. It stands as a significant and lasting achievement of the Whitlam government. We're very fortunate to have, I think, a quite remarkable lineup of distinguished experts to speak in our two panel sessions, but my role today is to introduce our first two speakers. Firstly, it's a very great honour for us that the Attorney General, the Honourable Mark Dreyfus, KCMP, has joined us to deliver the keynote address in this, the first of our series of seminars on Gough Whitlam's legal transformations. Colleagues, I had the opportunity of serving in the Federal Parliamentary Labor Party with Mark Dreyfus. I can say this, in my years in Parliament, I served with no one who had greater integrity than Mark Dreyfus. Not only that, but he is a politician who has made a real difference in this country for the better. He deserves enormous credit for his drive and advocacy to establish the National Anti-Corruption Commission and for his vision and courage to overhaul the administrative review system in Australia, which of course was another Whitlam government initiative. Mark, thank you so much for joining us today. Please welcome Attorney General Mark Dreyfus to deliver our keynote address.
Good afternoon, everyone. Could I acknowledge the traditional custodians of the land on which we meet today, the Gadigal people of the Eora Nation. Thank you, Uncle Michael, for the excellent welcome to country. I pay my respects to their elders past and present, and also to other Aboriginal and Torres Strait Islander people here today. I also acknowledge John Faulkner, both for his very warm introduction and his long and distinguished service to the Parliament and the nation. I thank John and I thank Justice Michael Lee for their invitation on behalf of the Whitlam Institute. We're joined today by a long list of distinguished guests, including my friend Chancey Paik, the Attorney-General of the Northern Territory, Justice Dina Yahia, Judge Kylie Beckhouse, and Whitlam Institute board members Kim Williams and Catherine Dovey. I thank the Whitlam Institute for establishing this series and for inviting me to speak on two matters in which I have a particular interest: the transformative legacy of the Whitlam Labor government and the vital importance of legal assistance in promoting equality before the law. It is just over half a century since the Whitlam government was elected. During his period of office, Gough Whitlam, the 21st Prime Minister of Australia, did not waste a day. 1 year into his first term, Whitlam told the House of Representatives, with some prescience, and I quote, "The changes we have made will remain, like all great Labor legislation, permanent landmarks in our history." Medibank, which became Medicare, family law reform, including no-fault divorce, equal pay legislation, anti-discrimination legislation, and Aboriginal land rights transformed Australia. They are permanent landmarks in our history, and Australian life is the better for them. The Whitlam government was at its core a reformist government. Whitlam was a lawyer. His Attorney-General, Lionel Murphy, was also a lawyer. And they both knew that laws and the legal system that gives them life can change lives. I went to university during the term of the Whitlam government. Whitlam inspired me and many other Australians. He demonstrated that with vision and courage, government can be a force for positive and lasting change. I hope that the Labor government that I serve will similarly be remembered, albeit with a little or even a lot more time in office to make a real difference. An area of utmost priority for the Albanese government and for me as Attorney-General is strengthening the legal assistance sector to deliver support to Australians who need it. Legal assistance is a key principle of the rule of law. This, in turn, is a key tenet of a healthy democracy. Legal assistance services ensure that equality before the law is more than an aspiration. Providers of legal assistance make access to justice a reality. Just weeks after taking office, Whitlam told the 1973 Australian Legal Convention, and I quote, "I am more than ever convinced that lawyers, and some of my most useful colleagues are lawyers," you can hear the voice of Gough there, "are able to discern issues, to express issues, and to devise solutions more than people of any other discipline in this country. But there is a very real risk that lawyers will appear to be beyond the reach of the citizen. The courts must always be accessible, but also the profession must be accessible. It must be relevant and it must be seen to be relevant." Right from the start, the Whitlam government recognised that access to justice was critical to achieving its goal of a just society. Out of that belief came the commitment to Commonwealth government involvement in Australia's legal assistance sector, a commitment that I share. Before Whitlam, the Commonwealth government had little involvement in legal assistance. It was a responsibility that sat almost exclusively with the states and territories and the private legal profession. Lionel Murphy had a clear view about what legal assistance could achieve. In 1973, he declared, "One of the basic causes of inequality before the law is the absence of adequate and comprehensive legal aid arrangements throughout Australia. Murphy understood the problem and he sought to fix it, beginning with the creation of the Australian Legal Aid Office. Established in 1973, the ALAO delivered for the first time a Commonwealth-funded national scheme that offered legal advice to those from disadvantaged backgrounds. Working in consultation and collaboration with welfare organisations, community groups and private practitioners, the ALAO established many of the practices that characterise our legal assistance sector today. Speaking in the Senate, Murphy said, and I quote, "I see the role of the Australian Legal Aid Office as taking the law to the people who most need it. I want to see small, unpretentious storefront offices opened up in the suburbs of the cities and in country centres. I want them to be the kind of offices to which the ordinary man or woman faced with a legal problem would go as readily as he or she would go to the garage with an ailing motor car," was 50 years ago. The ALAO improved access to legal aid, allowing low-income people to be eligible for legal representation. For the first time in this country, access to justice came closer to being a reality for all, not just for some. The ALAO was hugely popular. An independent survey in 1975 revealed extremely strong agreement among Australians there was a need for the service. This is one of the many examples of the Whitlam government's commitment to contemporary relevance, ensuring that policies and institutions were in step with the needs of modern Australia. The Whitlam government also contributed significant financial support to community legal centres, law society programs and Aboriginal legal services. The allocation of Commonwealth funding to Aboriginal legal services was particularly significant. The Whitlam government recognised that inadequate representation of Aboriginal people in the Australian legal system was a barrier to their equality in society. Acknowledging the vital work of the then recently created Aboriginal legal service in Redfern, funding was provided to open offices across Australia. Today, Aboriginal and Torres Strait Islander legal services exist in every state and territory and continue to provide culturally appropriate legal assistance services to First Nations people. The Whitlam government's decision to engage in national legal aid reform was a watershed moment in Australian legal history. Commonwealth support for legal assistance continues to have contemporary relevance, which is why I'm such a passionate supporter of the sector. Commonwealth support for the legal assistance sector now encompasses legal aid commissions, Aboriginal and Torres Strait Islander legal services, community legal centres, and family violence prevention legal services. Legal assistance providers increasingly offer innovative services that recognise legal need is often related to other kinds of need. Lawyers work alongside case managers, social workers, and financial counsellors. The success of these different service models is seen, for example, in health justice partnerships, which combine legal assistance with healthcare, and domestic violence units, which link up with other relevant services such as trauma counselling and emergency accommodation. As Attorney-General, my focus is on ensuring that the sector is not only adequately resourced, but that the administrative burden on the sector is proportionate and reasonable. To that end, I've recently gained the agreement of my state and territory counterparts, including Chansey, to remove clauses from the National Legal Assistance Partnership that forced legal assistance providers to collect and report excessive data and restricted them from engaging in advocacy. Ending the gag on the sector is vitally important. They are better placed than almost anyone in the profession to provide advice on law reform and legal assistance because every day they see how vulnerable Australians are affected by the law. The Albanese government recognises the the vital work of the sector and values its contribution to social justice and to safeguarding equality before the law for all Australians. All legal assistance providers, but particularly Aboriginal and Torres Strait Islander legal services and family violence prevention legal services, play an important role in achieving the outcomes under the National Agreement on Closing the Gap, to which this government is deeply committed. This government's first budget delivered historic funding aimed at closing the gap and improving the lives of Indigenous Australians. This included increased funding for Aboriginal and Torres Strait Islander legal services and funding for the national peak bodies for family violence prevention legal services and Aboriginal and Torres Strait Islander legal services. It also included $81.5 million to invest in up to 30 community-led justice reinvestment initiatives across Australia and establish an independent national justice reinvestment unit as recommended by the Australian Law Reform Commission, the largest funding package in justice reinvestment ever committed by the Commonwealth. One of the largest areas of the work taken on by legal assistance providers, especially legal aid commissions, is family law. In many cases, the risk of domestic and family violence in these matters is high. The National Plan to End Violence Against Women and Children recognises the significant role legal assistance has to play in addressing and ultimately eliminating family and domestic violence. Through the National Legal Assistance Partnership, the government provides dedicated funding for legal services for women. This government is dedicated to supporting the legal assistance sector so it can continue to deliver important services and increase access to justice. It is important to me that we celebrate the achievements of our legal assistance sector and recognise its far-reaching contribution. Today, Annmarie Lumsden will launch National Legal Aid's report on the benefits of providing access to justice. And I'd like to thank National Legal Aid for commissioning this important piece of research. The report details the enormous contribution legal assistance provides to Australian individuals, governments and society. Legal assistance services make our justice system more efficient and effective, reduce instances of domestic and family violence, improve mental health outcomes, and reduce the need for out-of-home care for children. These significant impacts are just a few of the report's findings. The report also notes that the pain and suffering caused by unresolved legal issues can have lasting intergenerational impacts. The failure to resolve legal issues can entrench disadvantage and expose children to violence, reduce their educational opportunities, and result in homelessness and other disruptions. This further demonstrates the essential role of legal assistance services in promoting safety, security, and ultimately equality for all Australians. It serves to demonstrate that equality before the law translates into equality of opportunity more broadly. I'm committed to ensuring that Australia's legal assistance sector is properly supported. The current National Legal Assistance Partnership will expire on the 30th of June 2025, and an independent review of the agreement is commencing this year. This will be a comprehensive review that will look at all aspects of the legal assistance sector, including the extent of unmet legal need. It will be an opportunity to show what needs to be done to equip the legal assistance sector to meet current and future needs. Lionel Murphy said that he wanted the ALAO to take the law to the people who most need it. This ultimately is what legal assistance does. As Attorney-General, I will honour the Whitlam government's guiding principle of pursuing reforms that have contemporary relevance. And I will not waste a day. I hope you find the remainder of the day interesting and productive.
Thanks so much, Mark. Well, our second speaker is Annmarie Lumsden, who has had over 30 years' experience in legal aid. Recently, Annmarie became the director of the Legal Aid Commission in the Northern Territory. I can say she brings unparalleled insight, experience and expertise to today's seminar. Please welcome Annmarie Lumsden to give our plenary address.
Thank you for your very kind introduction, John. I also acknowledge the traditional owners of the land, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. We were going to click onto a slide at this point. It's wonderful to be here with so many colleagues and friends as well. So there's a large mural on the side of the building where I work at the NT Legal Aid Office in Darwin. It depicts the ceremony in 1975 when Prime Minister Gough Whitlam poured sand into the hands of Vincent Lingiari, symbolically handing traditional land back to the Gurindji people on a 30-year pastoral lease. 8 years before, Vincent had led his people on the Wave Hill Walk-Off, also known as the Gurindji Strike, and the protesters' demand for return of traditional lands became a federal political issue. The story is celebrated in the Paul Kelly and Kev Carmody song, From Little Things, Big Things Grow. 8 years went by, 8 long years of waiting, till one day a tall stranger appeared in the land. And he came with lawyers and he came with great ceremony, and through Vincent's fingers, poured a handful of sand. Honouring that election priority, Labor under Gough Whitlam introduced the Aboriginal Land Rights Northern Territory Act, which became law in 1976. While there's much to admire about Gough, I share the view of many commentators that his legacy remains in his reforms to the Australian legal framework. Federal legislations, institutions and concepts that underpin civil society in Australia today and share a unifying theme to improve the lives of every Australian. As you've heard, 1973 is the defining moment in the history of legal aid. Access to the law was transformed when Gough Whitlam intervened to create the Australian Legal Aid Office. The ALAO was a centralised national scheme providing legal representation to poor and low-income Australians in civil, family and criminal proceedings under federal law. The ALAO also provided free legal advice and minor assistance to all people in legal matters generally. Interestingly, the ALAO was established by ministerial decree, a much quicker and far-safe mechanism than introducing legislation, and by changing the name of a section of the Commonwealth Attorney General's Department, which had previously given legal advice and assistance to ex-servicemen. By December 1975, 33 offices had been set up across Australia. However, while the ALAO was popular with the electorate, it attracted strong opposition from private practitioners. Ultimately, the Malcolm Fraser coalition government didn't act on its pre-election promise to abolish the ALAO, but instead decided it would make legal aid part of its new federalism policy and hand it back to the states. By early 1976, all Australian governments had agreed that new legal aid commissions would be established in each state and territory, that they would provide a legal service for both Commonwealth and state and territory law matters, and that they would be jointly funded by the Commonwealth and state and territory governments. Early in its term, the Whitlam government had asked the Law and Poverty Commission to consider options for providing legal aid, and the legislation creating legal aid commissions in all states and territories closely followed its recommendations. Legal aid commissions are governed by statutory commissions, independent of government, with a broad base of representatives from individuals and organisations interested in legal aid, and broad powers and functions, including to employ staff, establish offices, allocate funds to legal aid schemes and undertake research. They take a broad approach to legal aid which encompasses not just representation and advice, but also law reform, test litigation and community legal education. Legal aid commissions are part of the broader legal assistance sector, along with Aboriginal and Torres Strait Islander legal services, community legal centres, family violence prevention legal services and private practitioners. We each play a unique role in providing legal assistance to the most disadvantaged clients in our communities, acknowledging that our differences are our strengths. I've been a legal aid lawyer for over 30 years, beginning at Legal Aid ACT in 1990, then moving to Legal Aid New South Wales in 1998, and finally commencing at the Northern Territory Legal Aid Commission in December 2021. My career at Legal Aid has included a wide variety of roles, all with fulfilling and challenging experiences. And over the years, I've seen enormous talent and commitment to our work in promoting access to justice for the most marginalised and vulnerable in our community. A highlight of my career was being Executive Officer to the legendary Bill Grant when he was CEO of Legal Aid New South Wales. It was an exciting time of revitalisation and, in legal aid terms, prosperity. One of the many projects we did was assessing legal need in a more sophisticated way than just counting the number of applications received. And we developed a business case for legal aid commissions around Australia to fund the Australia-wide legal needs survey. I love working for Bill and I learnt a lot for him. And today, when I'm faced with a challenge, I often think, what would Bill do? By far the most challenging role I have is my current one as Director of NT Legal Aid. It is challenging because of the operating environment and the fact that the justice system is chronically underfunded and in need of substantial reform. The Territory is culturally unique. It's hot. In the top end, it's hot all year round. It has two main seasons, the dry and the monsoonal wet, which transition with the build-up when the heat and humidity are a test for any newcomer. There are unique dangers, crocodiles, box jellyfish and midges, and there's great beauty. Think about Catherine Gorge and Kakadu and the murals on the side of buildings. NT Legal Aid and other legal assistance services in the Territory operate in uniquely challenging circumstances because of our extreme remoteness and isolation, a vast geographical space with a small population, lack of access to goods and services, lack of housing and infrastructure, cultural and linguistic diversity, economic hardship and disadvantage to our First Nations people. While Aboriginal people represent 3.35% of the total Australian population, the Northern Territory has the highest proportion of Indigenous residents, an estimated 32%. As a result of colonisation and dispossession, many Aboriginal Territorians have experienced entrenched intergenerational social disadvantage, including poverty. The poverty is widespread and highly visible. Many Aboriginal people live rough in the long grass in urban areas throughout the Territory. Aboriginal Territorians are overrepresented as victims and offenders within the justice system. The imprisonment rate in the Northern Territory is 5 times the national average, and on top of that, Aboriginal men are imprisoned at 15 times the rate of non-Aboriginal men, and Aboriginal women at 14 times the rate of non-Aboriginal women. The Northern Territory has the highest rates of domestic, family and sexual violence in Australia, and the rate of children living in out-of-home care is twice the national rate. The statistics on the overrepresentation of children in detention are particularly alarming. In the Northern Territory, the rate of children in detention is higher than in any other jurisdiction in Australia, at almost 5 times the average national rate. But what's really alarming is that the proportion of children in detention who are Aboriginal is commonly 96% and often 100%. This means that an Aboriginal child in the Territory is 30 times more likely to be incarcerated than a non-Aboriginal child. In the 2 years from June 2020 to June 2022, the number of individual children entering detention for the first time in each year increased by 184%. The driver of this alarming statistic is the increase in the number of children on remand. In the month of June 2020, 31 children were held on remand. By June 2022, 88 children were being held on remand. The reason for this increase is the so-called youth justice legislative reforms introduced by the Northern Territory Government in May 2021. The aim of these reforms was to cut crime by automatic revocation of bail for so-called serious breaches of bail, which can include a breach of curfew, by stricter access to bail and by limited or one-off access to diversion programs. A further legacy of these reforms is the increase in children under 14 years old who have been exposed to detention. 22 children entered detention in 2020-21. The following year, 2021-22, the figure rose to 53, and of those, 7 were aged 10 or 11. The overuse of detention for children is contrary to principles upon which the Australian youth justice system is based, that a child should only be detained as a measure of last resort and for the shortest possible period. It's also contrary to national and international research providing evidence of the immediate and lasting negative effect of detention for any period on a child's well-being and rehabilitative prospects. One of the 16 socio-economic targets in the National Agreement on Closing the Gap is to, by 2031, reduce the rate of overrepresentation of Aboriginal young people in detention by at least 30%. This target reduction is on track to be met by all jurisdictions except the Northern Territory, which is going backwards. November 2022 marked 5 years since the Royal Commission into the Protection and Detention of Children in the Northern Territory tabled its final report to the Australian Parliament. Research undertaken by the Royal Commission confirmed a trajectory in which engagement with child protection services is a foreseeable pathway to later engagement with the youth justice system. 75% of Aboriginal children with a proven offence had previous involvement with the child protection system. The Royal Commission also highlighted the prevalence of trauma-related mental health issues for children in both out-of-home care and detention, and the lack of mental health assessments. Dr. Denise Reardon, Chief Psychiatrist of the Northern Territory at the time, gave evidence that child and adolescent mental health services in the Territory were delivered by multiple service providers using staff with varied levels of training and therapeutic approaches, and unsurprisingly, her evidence was that there were serious gaps in the services delivered, particularly for children in detention and in remote areas. Dr. Reardon's further evidence was that many of the children who were seen were not doing well at school, if they attended at all, and very few had been formally assessed for learning difficulties, attention and other executive functioning difficulties. Many suffered from fetal alcohol spectrum disorder, but again, they were often not formally assessed for this. This brings me to the very practical difficulties for my defence lawyers in achieving justice for children under 14 who are charged with a criminal offence when they seek to invoke the presumption of doli incapax, that is, that a child under 14 lacks the capacity to be criminally responsible. The eminent SC, Phil Bolton, who is Sydney-based but a frequent visitor to the Territory, has observed, more often than not, doli is reduced to a mere theoretical construct. The exigencies of gathering evidence of a child's cognitive development are legend, especially in the Northern Territory and especially in bush courts. The neuropsychological testing and assessment for cognitive functioning are expensive. Funding is woefully inadequate. When a lawyer can access testing, the history taking is hampered by language difficulties, inadequate or non-existent interpreting services, geographical isolation, parents who are unable to provide accounts of the child's upbringing, and a lack of health and educational records. Diagnosing fetal alcohol spectrum disorder requires complex assessments and accurate reports from early childhood and an accurate history of the mother's alcohol consumption during pregnancy. This type of an assessment is a luxury for most children, especially for First Nations kids represented by busy, overstretched ALS and legal aid lawyers. But this is just part of the picture. Actually, in many, if not most cases where doli is sought to be invoked, it is the defence lawyer who needs to actively chase the evidence that points towards their child client lacking the capacity to know that their actions were seriously wrong. This takes time and effort and money, actually public money. In my experience, among the wicked consequences of the presumption are that when a child seeks to rely on it, they can be held on remand for many months, often for a longer period than a sentence for the alleged offence if it was ultimately proved. That consideration can persuade lawyers and their clients to give up their right to require proof of criminal responsibility and instead enter pleas, particularly when the prosecution offers to accept a plea to a lesser charge. The second reason why my current role as Director of NT Legal Aid is challenging is that the justice system is chronically underfunded and in need of substantial reform. And of course, my primary focus is securing adequate funding for NT Legal Aid to provide services. We are fortunate to have the certainty of federal funding under the National Legal Assistance Partnership Agreement. The NLAP allows us to plan our services in the areas of family law, family dispute resolution, legal task assistance for civil law, health justice partnerships, legal advice, information and referral, community legal education, and our social support services. In stark contrast, the primary challenge for NT Legal Aid has been our deteriorating financial position as it relates to Northern Territory government-funded matters, representation in criminal law, and children in need of care matters. For criminal law matters, core NT funding has not included funding for services at courts where we don't have an office, colloquially known as bush courts, or for NT expensive cases, and we've had to rely on ad hoc arrangements to seek reimbursement. Last financial year, both mechanisms for reimbursement became unavailable, and in March 2022, we had no option but to make the difficult decision to cease granting aid for new matters at bush courts. This withdrawal of funding created a serious access to justice issue for remote Aboriginal communities in the Territory. NT Legal Aid has historically provided bush court services when Ngarja is unable to do so because of conflict. Our inability to provide these services meant that some very vulnerable clients were unrepresented. Almost 100% of people appearing before these courts are Aboriginal Territorians who are experiencing financial disadvantage and who speak an Aboriginal language as their first language. Involvement in the NT justice system is difficult at any time, but lack of legal representation meant that people didn't understand the charges they faced and didn't receive legal advice about whether they should plead guilty or not guilty. Unrepresented defendants can't identify a defence or conduct a complicated defendant hearing or understand matters in mitigation, which the court should take into account when sentencing. People may be sentenced to imprisonment who might not otherwise be if they had legal representation. While it looked pretty bleak at the beginning of this financial year, with the support of our new attorney, Chancey Paik, we have received supplementary funding and negotiations with the NT Government toward a funding agreement are progressing. We resumed bush courts in October 2022 and have our fingers and toes crossed that we will achieve an adequate level of ongoing funding which will allow us to plan and prioritise NT law services and to manage our budget. I also welcome the review of the National Legal Assistance Partnership Agreement, which is to commence early this year. In commenting on the terms of reference, National Legal Aid noted the importance of not only assessing legal need and Commonwealth legal assistance funding, but doing this alongside an assessment of state and territory legal assistance funding. A holistic assessment of the legal assistance system is necessary to understand the intersection between family law, domestic and family violence, child protection, and the criminal law system, particularly for Aboriginal people and communities. From the perspective of NT Legal Aid, this is crucial. For most legal aid commissions, state and territory funding is significantly more than Commonwealth funding, but that's not the case for NT Legal Aid, which receives less territory funding than Commonwealth funding. Under the NLAP, Commonwealth funding is calculated using a funding formula, but there's no mechanism for calculation of state and territory funding. The amount provided by states and territory is simply a matter of politics and luck. And unlike all other states and territories, most NT legal aid services are provided to Aboriginal and Torres Strait Islander people. In 2021-22, 74% of NT legal aid criminal clients were Aboriginal. The national average is 22%. The current Commonwealth funding model assumes Aboriginal control legal assistance services will provide legal services to Aboriginal people. While I support the primacy of Aboriginal controlled organisations providing services to Aboriginal people, this model fails to recognise that legal aid commissions are a necessary co-service provider for Aboriginal people who can't be assisted by Aboriginal controlled organisations because of conflict or who choose not to be. Finally, I have the privilege of speaking to a very recent report on the benefits of providing access to justice. Australia has provided global leadership in developing a holistic cost-benefit approach to analysing access to justice. In 2009, National Legal Aid commissioned PwC to develop a first-of-its-kind report that estimated the benefits for legal aid services that accrue from increased efficiency of the justice system. In 2019, the World Bank undertook a literature review of the key findings from various cost-benefit analyses of access to justice and legal assistance globally, and cited the PwC report as evidence of best practice in analysing and capturing the economic benefits. In 2022, National Legal Aid commissioned PwC to undertake an updated analysis of the benefits of providing access to justice with a focus on federally funded legal aid in family and civil law matters. The findings of the PwC report, titled The Benefits of Providing Access to Justice, are critical in providing a better understanding of the significant contribution legal aid services make, not simply within the justice context, but in terms of contributing to better outcomes for people experiencing disadvantage and the broader community. The PwC report estimates that legal aid services deliver approximately $601 million in benefit each year in the civil and family law areas. This corresponds to a benefit cost ratio of 2.25. That is, for every dollar spent, the benefit is $2.25. A benefit cost ratio is the key metric that government considers when assessing investment opportunities, and 2.25 is a substantial contribution. For example, Victorian Treasury guidelines state that a benefit cost ratio greater than 1 implies that an investment should proceed. The cost-benefit ratio of 2.25 has been assessed based on 3 key benefit categories that take a holistic view of the benefits of legal aid services. 1, efficiency of the justice system, 2, value for individuals, and 3, wider government and societal outcomes. This includes costs saved within the legal system, but importantly also includes avoided cost to individuals and government through addressing domestic and family violence, minimising out-of-home care, and reducing pain and suffering resulting from legal issues. Consistent with the underlying theme of Goff's reforms to the Australian legal framework, the biggest contribution legal aid services make is avoided cost to individuals. Legal aid makes a difference to people's lives, and it's pleasing to see that it is reflected across the board, including in an economic assessment of its value. I'm not actually releasing the report. It's going to be released in March, but I am pleased that I had the opportunity to present its findings. Thank you for your time, and I'm sure that you will enjoy the rest of the CPD. Thank you.
Well, thank you very much to the Attorney General for your very generous donation of time to this inaugural event. We know that you're very busy, and we're very grateful for your time and address. You made mention of the Whitlam government's great hallmark of legislative change under Lionel Murphy's tenure as Attorney General. And we're not yet halfway through the first term of this current government, and we're already bearing witness to the revival of this great ambition. So thank you so much for your time and your words, Attorney General. Annmarie, let me also thank you for your wonderful address. It sets the stage brilliantly for the 2 panels to come. Annmarie, of course, has been instrumental in the driving of reform, both within the criminal justice system and more broadly in the areas of domestic and family violence, family law and child protection, the right to silence and double jeopardy. Her experience in the issues of Indigenous incarceration and justice is considerable, And so I look forward to the next two panel sessions and some great questions from the floor.